Good morning everyone, my name is Michelle, I hope you're doing well. Welcome to another video. It is Thursday the 22nd of February. In this video we're staying with the Delphi case today. And although I've made 3 videos in the last week, 7 days ago, 6 days ago and then yesterday, that's not technically about Delphi, just inspired by it. Go and watch that video. It hasn't been very popular over the last 19 hours. But it's scary. It's worth 16.5 minutes of your time. And if you watch it on, some sped up speed, you can watch it in even less time. But it's been a solid 12 days since I talked about the documentation, all of the court filings. 12 days. And there's been some court filings. So, what we're going to do? We're going to talk about it. You know why? You betcha. We're all still watching as closely as a hawk watches a gull.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
So what has come out since last I spoke about court documents? This is the last time I spoke about court documents. This was a petition for clarification regarding the contempt hearing. Do you remember the contempt hearing that Slickless Nicholas McClelland has brought to the court? He says that Andrew Baldwin and Brad Rosie are contemptuous. Contemptuous, I tell you, for all of the reasons that, hold on a minute, the Supreme Court of Indiana said didn't constitute gross negligence and does not in any way equal contempt of court. And this document went through the reasons why it doesn't and asking for further clarification from the court as to why this contempt hearing has been brought in the first place. Baldwin and Rosie are without sufficient notice as to the details of the state's allegations and how or why specific acts are alleged to be contemptuous. It makes perfect sense to ask for clarification. You know, when you were at school or at college and you weren't sure about something, what did your tutor tell you? What did they say? If you're not sure, put your hand up and ask a question. Well, I'm very glad that Frances C Gull went into the judiciary rather than teaching, because her students would have been complaining. You bet you she would have lost her job. If she'd have been a teacher at a school, college, university, she would have been hauled in to the head of department's office, hauled over the coals. She'd have been on disciplinaries. And eventually, they would have tried to get rid of her. I promise you that. Listen, I've seen it. I worked for over 20 years in education. I've seen people who just couldn't work with students, couldn't put themselves in the mind of what it was like when they were a student and being unsure and being scared to ask questions and then plucking up the courage to ask a question and to be supported when you ask that question. And you would think that a judge who was unbiased towards either side, holding up the scales of justice and each side having equal measure, you would think that Frances would think about these kind of things. But no, it doesn't work like that in this court. Do you know why? Because Judge Frances C Gull, the dishonourable herself, can't do that. Why? Because she's biased. She's biased. There's no other explanation. Either that or she's just a very, very, very bad judge. I don't know. I don't know what else to tell you. So point 5 here is very important. It seems clear that the state is really attempting to charge indirect criminal contempt. As such, a separate filing and initial hearing would be contemplated. Attorneys Baldwin and Rosie respectfully request notice whether the March 18th, 2024 hearing will be a formal advisement of the specific allegations or whether the court anticipates hearing testimony and receiving evidence. They want to know the nature of this. Is this another attempt to ambush them? You've got to ask that question due to all of the shit that went down in October. You know, they're trying it again, just via a different route. Well, it didn't work. This case is going to end up back in the Supreme Court, I tell you. Anyway, there's been filings, new filings. So I had to go to Reddit, because I've got all of these. I've saved them all, but instead of just going through them, Reddit, Delphi Docs, they have all of these filings, and it's easy to work through what came at what time, rather than opening all the documents and looking at dates. Okay, so... why do they put adverts everywhere these days? It doesn't matter what site you're on, so it's flaming adverts. You see, look, this is who this is about. This is exactly who this is about. Are we any closer to getting to trial than we were in October? No, we're further away due to all of this crap that keeps happening. So that was the 7-year mark. Question about the bullet. Talked about the bullet a few times. Okay, so this is Slickless Nicholas respectfully notifying the court that the state has turned over the discovery information that the state intends to use at the hearing on contemptuous conduct in compliance with Indiana Supreme Court rules. So the state intends to call specific witnesses and introduce various pieces of evidence at the hearing on contemptuous conduct scheduled for March 18th, 2024, 9 a.m. at Allen County Superior Court. So that makes me suspicious that she wants to do this on her home turf. She's got the home advantage. There's a bunch of psychological evidence from sports psychology about the power of the home advantage. It's actually not as advantageous as you think in some regard. However, I'm not an expert in that topic. But she wants it on her home turf. I suppose then the defence has got to read between the lines that if the state is bringing witnesses, they should as well. Because this contempt hearing is going to get serious, isn't it? What else do we have? We've got this. This from David Hennessy. Request to use a laptop and a phone at the hearing. I don't see her ruling on this. I may have missed it. So this is David Hennessy acting as the attorney for Baldwin and Rosie. Why? Because in this case, the lawyers have lawyers. That's why. Why do you need to ask to bring a laptop and even a phone to your job? I don't get that, but I think she's stern about these kind of things. Like she confiscates your phone and sells it on eBay. Okay, oh, this is interesting. The defence has subpoenaed 4 witnesses for depositions, and this is for the contempt hearing. Notice filed of depositions by non-stenographic means. Request for subpoena for Sergeant Jerry Holman, the Indiana State Police. Request for subpoena Ben Rector, don't know who that is, from the Indiana State Police. Request for subpoena for Stephen Mullin. Is that Carroll County? And then request for subpoena for Mitch Westerman. So these are going to find some interesting information. Interesting, isn't it? So we've got some amended pleadings filed. This is for the transcript. Which transcript? The transcript for the June 15th, 2023 hearing. This is the safekeeping order. Do you remember? It was one of the things that the Dishonourable Frances C Gull just ignored when they asked for it previously. This answers 2 questions because it's relevant to the trial or a possible appeal if he's convicted, but it's also relevant to the contempt hearing. Slickless Nicholas is going to argue, like they did with the gross negligence, that Baldwin and Rosie lied in June. What else do we have? Well, this is the response to the state's motion to compel discovery. So this is in relation to the trial, not the contempt hearing. Are you keeping up with this? So on January 27th, the state of Indiana filed a pleading entitled "The State's Motion to Compel Discovery." Within this filing, we find out that the state was actually holding a lot of discovery back, when in October they said that they'd given everything to Baldwin and Rosie regarding the discovery, but they found some more, probably, down the back of the sofa, under their bed. I don't know where they keep this stuff, but after reviewing just a portion of the evidence contained on the hard drives and the e-discovery drops, it became apparent to the defence that the discovery received includes evidence the defence believes it has never viewed or had a chance to view. The state and defence are also in ongoing communications regarding evidence that may exist but has not yet been found by the defence. Regardless, the defence is reviewing the discovery as quickly and efficiently as possible, often late into the night, to determine what discovery exists on the hard drives that were already known to the defence on October 12, 2023, versus new discovery that the defence does not believe it has ever viewed. And evidence that the defence believes exists cannot be located in the discovery provided. The volume of discovery is massive, including minimally 20 hard drives, as well as 6 separate e-discovery emails. And as of the date of filing, the defence has had less than 3 weeks to review the discovery. Doesn't matter, because Judge Frances Gull doesn't care about you. Oh yeah, that Crime Nation thing came out. I can't watch it in the UK, so it's annoying. Anyway, this is the latest set of filings. And this is Judge Gull, like a Cyberman. She reminds me of a Cyberman from Doctor Who. I don't know how well Doctor Who is known overseas to the majority of my audience. It's like an easy-to-watch sci-fi programme. Alright, it's been running for years. But the Cybermen, they're some of the bad guys. They come along, they're like stomp, they're like made of metal, and they stomp, and they go delete, delete, delete. Well, Gull is like a Cyberman, but instead of delete, 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 she goes deny, deny, deny. And she denied some more things. Okay. So, Defendants Counsel's motion for summary denial of the state's verified information for contemptuous conduct has been reviewed and denied without hearing. Defence Counsel's petition for clarification regarding contempt hearing, filed by Attorney Hennessy, reviewed. The court has scheduled a hearing on the state's pleading and therefore denies the petition without hearing. So, further clarification, no. Can't ask for that. No. Just denies it. Denies it with no reason, no law included here. Just no. Deny. Deny. Just deny. Gonna deny it. What's she like? Frances, you fooling no one. Yeah, absolutely. Totally rogue. She totally is. Back to the Supreme Court. It's crazy. Grudge Gull. Oh, I'm keeping that one. Grudge Gull. You've got to laugh. Seriously, you've got to laugh. If you didn't laugh, come on, you'd cry. But anyway, the original hearing, right? You all remember this. It was 9 a.m, wasn't it? Well, now she's slipped in another hearing. So now there's 9 a.m. and there's 2 p.m. So what's the other hearing about? Is she going to hear the witnesses in hearing 1? That's the contempt hearing. And then she's going to, at 2 p.m, going to do her own little thing and disqualify Rosie and Baldwin. I don't know. What's the second hearing about? I guess we're going to have to wait and see, aren't we? We've got a while to wait yet. What else is going to happen in this case? What else can happen in this case? This is going to be tied up for months, if not years. This is crazy. Absolutely diabolical. Diabolical. No other words. All right, let me know what you think in the comments, and I'll see you in the next video. Bye, guys.